Good day to you and welcome to another Paddocks Club video tutorial. Today we're going to talk about some proposed amendments to the Sectional Titles Act. The details of these amendments can be found in Notice 808 of 2012, Government Gazette 35766, dated and published on the 5th of October 2012, and you can see here the web address at which you can download the original if you want to go through it, as I think that you probably should, although I must say that these changes don't affect management of sectional title schemes tremendously, except in areas which I will highlight. There is the amendment of Section 1 in regard to 3 definitions: architect, developer and land surveyor. That's just really updating to take account of modern legislative changes. There's the amendment of Section 4. This deals with giving tenants notice when you convert a scheme to sectional title. Again, not awfully relevant for most of our purposes. The amendment of Section 7. This is important. It provides that the Surveyor General will investigate draft sectional plans and prescribe documentation. This goes together with something that will be mentioned later, but in essence the Surveyor General will take responsibility for examination of sectional plans and those consolidation and subdivision. The extension of schemes according to documentation lodged at the reservation stage on opening of the register now will be the SGO's brief. There's the amendment of Section 14. This is a minor issue catering for cancellation of a sectional plan on authority of order of court. It's always been able to be done, but there's been no provision in the Act for it. The amendment of Section 15b I highlight, not because I think it affects sectional title scheme management in a major way, but it caters for the transfer, more completely caters for the transfer of a fraction of an undivided share in a section. So the fractional ownership, time sharing, call it what you will, is facilitated by way of this amendment, and that will provide developers with further opportunities without doubt. Section 17 is amended to provide for registration of transfer of part of the common property. That's always been there, but now it's better provided for. Consents of owners and the holders of real rights are better provided for. Section 18 is amended to provide for the cession of mortgaged real rights of extension, mortgaged real rights of exclusive use areas. This again is just filling out the Act with detail, which the Deeds Office was winging it with until this point. No serious damage. It's just fixing up and perfecting the Act. Amendment of Section 19 to provide for the cancellation of part of a section pursuant to an expropriation. That again a technical issue. Amendment of Section 24. This is perhaps the most important aspect from a management perspective, and that is that the deviation percentage at which the requirement to get the bondholders' consents for all units in the scheme kicks in has been moved from 10% to 20%. In other words, from being able to add a tenth to your existing floor area without getting these consents, you can now add a fifth of the floor area, which I think is quite substantial. But if there are to be people who would object to this, it would probably be bondholders, or it might also be managing agents, I suppose, if they thought this was a bad thing. There's the extensive amendment of Section 25 to provide for the consent of bondholders with the registration of a sectional plan of extension, to provide for draft sectional plans and prescribed documentation to be lodged with the SGO. That's that reservation documentation I spoke of earlier, and to provide for the deviation from the particulars of the plans by arrangement by consent of the bondholders and holders of registered real rights. This is tuning up what the courts have said should be done and making the Act comply with that. Section 27 is amended to provide more fully for the issuing of more than one certificate of real right of extension and more than one certificate of real right of exclusive use area. Again, technically a conveyancing issue more than a management one. If you have comments on any of these, your comments can be emailed to Mrs. Antoinette Reynolds, and her web address is, her email address is given there. Your time by which it has to be done is Thursday, the 25th of October 2012. And if you have any inquiries, you can get her on this telephone number 012-338-7236. Thank you for joining me in this Paddocks Club video tutorial, and if we have any questions, we can deal with them in the discussion forum.